Okay, so I suppose everyone is here. We can start, right? Okay. Today we have around two topic that we need to discuss today. We will discuss today actually, right? Topic number 7 and topic number 8 of the law optional. Okay, in the constitutional law, this is serial wise, right? Topic 7 and topic 8. Okay, the structure will be same, right? The structure will be same. That is, I will talk about the main subtopic that need to be studied, and also then I will be talking about the whole case laws and the important thing that is needed for this lecture. Okay, so I will be talking about everything in detail. Clear? Okay, so let's start. Uh, if we will see topic number 7, so topic number 7 basically says center, state and local bodies, right? Now there is rarely a question on local bodies even if it is in the syllabus. Okay, so mostly the question is from the distributive and legislative power between union and states. Okay, that is the syllabus. Okay, administrative relationship among these three, right? And eminent domain, state property, common property and community property. Okay, so this is the topic that is the given in topic number 7, I mean subtopic given in topic number 7. Then we have topic number 8, legislative power, privilege and immunities. Okay, now if you look at these topic in detail, right, one thing is very aptly clear here is that you have to start with the meaning and the distribution of legislative power, right? You have to start with the meaning and the distribution of legislative power. Now someone is saying that not audible. I think it is audible for everyone. Yes or no? Okay, so meaning and distribution, right? Now the question is what is the meaning of legislative power, right? Then you have to understand not only the meaning but the nature, right? That how the legislative power actually functions. Is it a plenary power of the union or the state, right? Or it is something which is given to them by the constitution and constitution can take it away. Okay, so that is the meaning of nature of the legislative power. Okay, so that point you have to study in detail. Then how this nature, we will go into individual article, obviously I will go in this lecture as well, but how this nature is somehow one of the attribute of sovereignty. Okay, see, ultimately whenever there is a concept of law, right, so law is a command of sovereign. So if you are giving someone authority to make law, does it mean that you are giving someone attribute or one of the section of sovereignty to him? That does that person or that institution on which this law making power is conferred, does that institution will become sovereign, right? So that in that sense you have to understand the meaning here. Okay, then you have to talk about doctrine of legitimate expectation. That basically precisely means that if you make a law and in accordance with that law I have performed certain act, right, then later on you cannot take away that law and say that my act is invalidated. Okay, so I have some legitimate expectation from you. Okay, now that applies to the legislative power as well as the administrative power. Okay, as well as the administrative power. Clear? So both thing has to be understood. Okay, legislative as well as administrative power, doctrine of legitimate expectation, right? So do read that particular thing. Then you will come about different types of theories related to the legislative power. Okay, although it is not mentioned in the syllabus, right, it is simply the distribution, but still there have been question on theory of territorial nexus. It means applicability of the law, where it will apply. Okay, or what are the you can say that what are the ratio on which the law will apply, right? Which part of the country the law will apply, right? Both union law as well as the state law, right? So that is the core concept of the theory of territorial nexus, right? It is basically article 245, right, that defines the territorial limit of the legislative power, right? In fact, it in the case of union it indirectly says that the union law will not apply only if only on the ground that it have extraterritorial application, will not get invalidated, right? So the law made by parliament will not get invalidated only by the cause that it have extraterritorial application, right? But in the case of a state it clearly says that it will apply to the state jurisdiction itself, the state territory itself. Okay, so that is the meaning of territorial nexus. Does it mean, I have discussed a case also, I will discuss later, right, that does it mean that the union law will apply anywhere in the world, right? The answer is no. It must have a territorial nexus. We will cover that territorial nexus part. We have a case law today also. Okay, then we will talk about extraterritorial operation of parliamentary law, right? It is basically article 245(1) here, and this is actually article 245(2), right? So there have been multiple time question on this itself, right? What do you mean by territorial nexus, right? And they give a condition or they give a situation that okay, in this case whether the this law will apply or not, parliamentary law will apply or not. Understood? So that particular point has to be taken, right? It means Article 245 1 and 2 has to be studied, right? Both relates to territorial nexus only. Okay, so that one thing you should definitely keep in mind. Then you should come for different principle of interpretation. Okay, now you must have studied in your law colleges. If you have not, you should study, right? There are around 5 to 6 principles, right? Now one of those principles was actually asked in your GS paper 2 as well, right? Pith and substance doctrine, right? So the law student will do very nicely this year, no doubt about it. I am also hoping, right? Almost 7 to 8 of my students are giving interview this time, right? So I am hoping they will be in toppers. Okay, so different principle of interpretation of list. What are those principles? Plenary power. Okay, that is one of the principle, that if law confers you to, constitution confers you to make a law in that particular field, then it is absolute in nature, right? That is the meaning of, one of the meaning of plenary. There are obviously other attributes of plenary, but it is still one of the important meaning of plenary. Okay, then liberal and harmonious construction. In the case of conflict, court use this liberal and harmonious construction. One, there is a gas factory case I have given here, I will discuss also. Then incidental power, right? So if a law gives you a particular subject, then everything related to that subject you have power to make law. Pith and substance rule, right? Pith and substance, you must be aware, right? In GS paper 2, right? PS, it was asked, right? Pith and substance, basically this is a biological word, right? If you have seen bamboo, in the case of bamboo, the hollow portion is basically called pith, right? And this portion is basically called substance, right? So whenever there is a question regarding the conflict or the legislative competency of the law, it is the pith which is irrelevant, it is the substance which is relevant, right? So that is the meaning of doctrine of pith and substance. Okay, so you should read in detail, and along with the case laws for each and every doctrine you should at least remember 2 case laws. Okay, so try to find that out, right? So go to this MPGN or whatever you have, read this doctrine and important cases, okay, and note it down. Then colorable legislation, multiple times a simple question, right? What you cannot do directly, you cannot do it indirectly. Multiple times this question have already been asked. Okay, doctrine of eclipse is basically, I have already told you, it is covered in the case of fundamental right. Okay, it is not here. Okay, and their criticism, right? That criticism is also important, right? For each and every doctrine, you should understand that where it applies, right? In which situation this doctrine will apply, and which situation it will not apply. Okay, so the criticism of each doctrine should be there, right? Like in the case of pith and substance, one criticism is that it is too wide, right? Court can come up with anything and say, okay, it is not pith, it is substance. Okay, so that sort of criticism has to be there for each and every of these doctrines. Okay, these interpretation doctrines, right? So that one thing you should keep in mind, criticism, because criticism leads to philosophical question related to that particular doctrine. Okay, that how far do you think this doctrine have settled the law, right? So it means you have to write the philosophical basis of that doctrine itself. Okay, so the criticism of that doctrine has to be understood. Okay, so that one thing you must keep in mind. Then you will come to the residuary power and the repungency, right? It is basically, sometimes question comes, right? If a law A have been passed, right, and state have amended that law and passed A dash, again the center have amended the same law and passed A double dash, right, and a person was convicted when the state law was passed, what will be the current situation? Okay, so conflict, basically they are scenario based questions. Okay, so ultimately it is the state law that will get valid. Okay, so that particular thing you should keep in mind, right? It is very simple doctrine actually, doctrine of repungency, you can read that down. Now when I am saying criticism, that this criticisms has to be attached in the in the case of this distribution of legislative power, right? That how these doctrines are evolved in such a way that the union parliament gets more power rather than the state parliament. Okay, so that particular thing in that aspect has to be kept in mind while reading the criticism of each and every doctrine. Understood that point? So that is one thing you should keep in mind definitely. Okay, that is a very important part actually. Okay, now then we will come to the administrative relationship, right? Mostly the administrative relationship question is with respect to that how this the structure, administrative structure functions, and it is disproportionately balanced towards union. Okay, so you will cite all the major articles, right? You must have seen the articles, right? That all the union law must be enforced first, right? Or the executive power of the state should be used in such a manner not to hinder the executive power of the union. Okay, so those sort of provision has to be studied, so that you can give an example, right? You can give an example that how you can actually You can give an example that how these provisions actually gives power to more to the union than to the states. Okay, so that sort of criticism you have to study in administrative relationship. Okay, remember, do read this article 256 that talks about that if there is instruction passed to the from the union to the states, and if they do not follow, that will amount to the breakdown of the constitutional machinery. Okay, and ultimately that is a ground for president rule. Okay, so in that scenario you have to actually read that down. Now in the case of financial relationship, the next subtopic, see, it is not given above, right, but still it is important here. Okay, now if you look about the financial relationship, the only question in the financial relationship they ask is basically with relation to finance commission, only finance commission, right? So do read the provision of finance commission. Okay, that is very, very important. Okay, now if you look about the provision of finance commission, right, normally speaking there are two type of basically distribution, right? One is called grant in aid, right? It's sort of a constitution says that okay, I know that the parliament have the ability to earn more, right? So some money has to be transferred to the states. Okay, that is the grant in aid. And second is the sharing of taxes, right? And there is third provision also, that the money that will be giving you have to give to the local bodies, right? So that was with the recent amendment, right? So that is not much importance, because that is subject to the state law, right? And ultimately the state don't want to give money to the local authority, right? So basically these two. Okay, so in that respect you have to study the constitutional provisions. Okay, go in detail into the constitutional provision. You will see that in the constitution, even the topic is also mentioned that okay, these taxes you have to give, these taxes you can skip, right? So everything has to be written as per the constitution. I mean, it has to be read as per the constitution. Then a very fundamental aspect, even though not mentioned multiple times, the question comes, that is the trade relationship between the union and state with relation to tax. Okay, like the trade and commerce in India shall be free, right? That is one of the statement of 301. Now what do you mean by free? Does it mean the tax cannot be imposed? That is governed by 302 to 307. Okay, and the interplay between these two has to be studied. And a very recent argument with relation to compensatory tax, right? Normal the tax has passed the muster that okay, tax is no way a barrier, right? But when an extra tax is imposed, compensatory tax is imposed, does it mean that will amount to a barrier and the violation of article 301? Okay, and the court have upheld that no, after Naveed Jindal case, that compensatory tax cannot be said to be a barrier if in lieu of that compensatory tax the state is providing you some facility. Okay, then that is not a barrier. Tax normally has been held that it is not a barrier at all, but compensatory tax also have been held is not a barrier at all, with a string attached that if the state is providing in lieu of that compensatory tax some money to you, right, some benefit to you, that particular industry, then the compensatory tax is okay. Okay, so that is one thing you have to keep in mind with respect to compensatory tax. Okay, so that thing please keep in mind, and that is very much important case. And this Atabari, actually Atabari tea, there is a tea here in Assam, right? There is a badi is basically called garden, right? Atabari tea case. Okay, so that was the case where the tax was held as good, it was not held as unconstitutional, right? And then the compensatory tax, I have given that case as well, right? We will read that. Then you will come to the eminent domain doctrine. Now when you talk about eminent domain doctrine, in 5 years, last 3 years, one question was asked. Okay, now simply study eminent domain. It is a power of of the king to tax its subject, right? So that is the basically the meaning of eminent domain. Okay, then you compare this eminent domain with the police power, tax power, and the interrelationship between these three articles related to the property. Okay, that is article 31A, B, and article 300A, right? And as well as this land acquisition and act. Okay, so that has to be studied along with it. Okay, so that one thing you please keep in mind. Okay, then only you can understand and answer these questions, right? These questions, eminent domain can also be sometimes used as a giving an effective argument with regard to tax also. Okay, just as a passing reference, not as a whole, but as a passing reference, right? Now this eminent domain is very relevant in paper 2 as well. Okay, so eminent domain is very interesting, right? Then you will also read the case laws which say that okay, eminent domain doctrine have certain condition attached to it, right? In India, the eminent domain do not mean that you are exercising a sovereign power and all the land will belong to legislature. No, it is subject to certain doctrine, certain exceptions. Okay, so those case law has to be studied. I have written an article here about this on de facto law.in, right? So you go and see that article, right? So that will be very good. Then we have legislative privileges, right? Now this legislative privileges, there are three things basically attached: the meaning of legislative privileges, right, and how it has come under the attack by the parliament, by the judiciary, and what will happen when there is a conflict between the power of contempt of judiciary and legislative privileges. Okay, because legislative privileges also include power to punish for its contempt, and the court also have a power to punish for its contempt. Case of Singh, in Ray Kesav Singh case, very important. And its judicial scrutiny, meaning ki when it comes under the conflict with fundamental right. So what will happen when the legislative privileges exercised by the authority, that is mainly the speaker or the chairman, when they uses it, can that will amount to a law under Article 13? Means, is it subject to Article 13? If the answer is yes, then does it violate fundamental right? If it violates fundamental right, can the decision be quashed? Okay, so that is the concept that I am saying, judicial scrutiny, right? So legislative privileges, its conflict with fundamental right, and its conflict with basically power of contempt of the court, right? Now this year there was a question, and the question was exactly with that I gave in test series, that there have been a constant attack, or you can say constant there have been between judiciary and executive, right? Judiciary and legislature, right? So both have been quite interesting, right? Lot of constant fight have been going on, right? So that I have given the question, and that was there itself, right? So each year almost you can find one question from this legislative privilege. So it is a very, very important topic. See, in fact, in the top you will see legislative privilege have been given as a separate topic, right? And I have already told you in the last 5 years, from each topic there is one question, right? So you can definitely say that legislative privilege will get one question at all. Yes, Keshav Singh, Indra Keshav Singh, I have given that case also, I will read that also. Okay, so that is the points, subtopic that you need to study. See, it seems to be a very small topic, right? But it really is a very, very big topic, right? So a lot of things has to be studied. Now you cannot pick and choose. You have to study each and every topic, right? Because the questions directly comes from it. Okay. Now let us start with the important case laws, right? Now I have given 5-6 case laws, and I will discuss it. First is this State of Bombay versus RMDC, right? This is basically doctrine of territorial nexus, right? A person was there, right? A tax was levied on the tax, right? And that tax lottery was, throughout India, the people actually purchased that lottery. Now the question was that where the State of Bombay, can it tax it or not, right? The court held that there is sufficient territorial nexus. Why? Because offices were in the Bombay, paper were issued in the Bombay, prize were issued in the Bombay. So there was sufficient territorial nexus. So even if the business is done anywhere else, still the law related to tax will apply to this particular RMDC. Okay, so that is the doctrine of territorial nexus. Okay, with respect to state law. With the parliament law, multiple other case laws are there. Okay, see here, the court have said, the court have held that a sufficient territorial nexus exists for the State of Bombay to tax the newspaper if there is a sufficient nexus between persons sought to be charged and the state seeking tax him. The taxing statute would be upheld, right? It will be not discarded on the ground that it have extraterritorial application. Okay, so what do you mean by sufficient nexus? It is just in one example. You should read 3-4 more case laws concentrating on the fact, the meaning of sufficient nexus. Okay, so that is the ultimate case law, I mean the first important case law. Then autonomy of legislative power, right? How the legislative power, the court have interpreted that the legislative power that the state have, right? That the state legislative power cannot be absorbed by the union. Okay, so I have given 2-3 case laws, right? You can read it once. Javed versus State of Haryana. Right? It was a Panchayati Raj provision where the Haryana state passed a law that if you are not a graduate, if you do not have children more than 2, right, then you are not eligible to fight an election, right? Now this law was obviously challenged on the ground that it violates fundamental right, and it is against the union legislature as well, right? Because union have passed this People Representation Act, and there is no such thing in the People Representation Act. So how can the state of Haryana in a local statute pass something like this? The court held that no, the state of Haryana have complete power to make law in their subject, and if they are choosing to do so, even if in essence it is against the union law, it doesn't matter. Right? It is a very interesting law, right? Recently, I think in 2012 also there was a unique law that they said that if you are not at least 8th standard, you have not taken the education, you are not eligible to become the Panchayati Raj member, right? So that was also upheld. Surprisingly, that was upheld, right? So that was a very interesting case actually. It means that to become a prime minister, you need not to be a graduate or 8th pass or 5th pass, but to become a member of panchayat, you need not to be, right? The court, actually, the Supreme Court reasoned that no, we have to usher reform, we have to come up with new innovative solutions and somehow upheld that particular law, right? Obviously, people, jurists criticized it, that should not be there. In the case of Rajasthan also, yes, that is very correct. Kolkata gas and the state of West Bengal. Yes, that was I was telling the plenary power of the legislation as well as the related to it, right? See, the word was gas work, then the word was industry, right? The court held that the interpreting Article 24 and 25 of the list to harmoniously. Okay, so there can be industry which comes up with a gas work, right? So does it mean that gas work the only union can legislate and industry the state can legislate? The court held that no. If the purpose is to legislate industry and it happens to be a gas work, then the union cannot come and say that okay, gas work comes in my list. No, not at all. Okay, so that is the harmonious construction that the court gave there. Okay, so this is very, very important case. But later on, so that this case do not arise, the entry gas work was actually deleted. Okay, and it was moved to the concurrent list, right? So this was the only judgment perhaps, right, for which the constitutional amendment was done so that the question do not arise. It means the government have accepted that okay, the court have somehow favored me, right? There was certain lacuna in the constitution itself, so I have to rectify that lacuna, right? So it is a very interesting judgment actually. Kolkata Gas Company, 1962. Justice Iyer was part of this. No, not Justice Iyer, Justice Subbarao. Sorry. On that interpretation could not fall within this list either for industry. That's the same thing. Okay. Then let us come to next important case, state of Bihar versus Kameswar Prasad Singh, right? It is the same case that triggered basically for this Keshavanand Bharti, the whole trail of cases. Okay, Kameswar Prasad Singh, he was one of the Maharaj of Darbhanga, district in Bihar, right? And there a law was passed, Bihar Land Reform Act. And this, if you will read the constitution, this is the first law which have been given in the 9th schedule, right? And somehow, obviously the judges of the Patna High Courts were also Jamindar, right? So they struck down this parliamentary law, right? And that led to all the, First Amendment and everything, right? Ultimately, everything comes down to land, right? So in that case also, the court basically, applied the doctrine of culpable legislation, right? That in the name of this land reform, you are taking away the right of property, okay? So that is the crux of, that is why I have given this case, right? So that you will remember, right? It is related to the Keshavanand Bharti actually. Okay, then let us come to the case related to trade and commerce, that 301, right? Now if you will look at the 301 and up to 307, first important case is Automobile Transport Limited versus State of Rajasthan. Okay, here a tax was required to be paid in respect to motor vehicle used within the state in any public place or kept for use in the state. The appellant carried on the applying stage carriers, notices were issued, this. Since the court ruled that the tax was not hit by Article 301. Okay, what is Article 301? That the trade and commerce shall be free, right? So the question was, extra tax which have been levied by the state of Rajasthan, that they said it is a compensatory tax. Does that compensatory tax violates 301? Right? The court held the answer is no. With a string attached, if that state is providing something beneficial to you, right? Then that particular tax will be upheld totally. Okay, now someone raise your hand. Please do not raise right now. Let me finish it, then I will come to the questions. Okay, let me first finish it. Okay, then it liberalized the concept of basically, right? It liberalized the concept of basically compensatory tax, right? So please read that, it is very important. Then we have Naveen Jindal case also, that is also important case, right? Then privilege and fundamental right, I have already talked about it, right? One case I have given here in Ray Keshav Singh. Article 21 is not subject to legislative privilege, but it is, vice versa. A person can move courts for enforcing his rights of life and personal amenity by appropriate proceeding, basically by writs. Okay, so that is the one point important thing. Oh, Abhishek Yadav asking interesting question, 70%, right? And that I will amount if, I will suggest you file a PIL, right, in the Delhi High Court, right? Let us see what the court suggests, right? But I think, they are giving online passes, right? So I suppose, that particular law will be sufficient. That will be upheld. That will be upheld. There is no doubt about it. Okay, right? So this in Ray Keshav Singh, okay, so what is the, if there is a conflict between fundamental right and the legislative privilege, so obviously it is legislative privilege is subject to fundamental right. That is the final ratio. Okay, so that one thing you should keep in mind. Okay, that is an important case itself. Okay, now let us come to the previous year paper. Right now, if you look at the previous year papers, I have taken out, there were a lot of questions, but I have taken out only 5 to 6. Right? See, discuss the legislative power of the union and state as provided in the constitution on the basis of subject and territory. Right? Territorial nexus, if they are asking. Okay, very simple question. Similarly, critical note on doctrine of legitimate expectation. See, that was not in syllabus, but still you have to study it. Okay, so that is why the subtopic that I am telling you, read each and every subtopic, even if it is not a part of syllabus. Okay, because the questions have been there. The doctrine of pith and substance introduces a great deal of flexibility into the otherwise rigid scheme of the distribution of legislative power. See, that is the criticism, or you can say not criticism, the philosophical aspect, that how pith and substance doctrine is basically helping the legislature to evolve and the court to uphold their laws. Okay, so in that sense, that is why I keep saying you that in judiciary the questions are different, right? But in UPSC the question, more philosophical aspect has to be studied. Understood? Not only the case laws. Okay, so please keep that particular thing in mind. Similarly, a federal government is a legalistic government, a characteristic feature of which is the allocation of the power between union and states. Explain the provision regarding the state and central relation in the field of legislation and administration. See how tough question it is, that you have been asked the legislative relationship, various doctrine, you have been asked the administrative relationship and the article attached to it. Now the question is, if you write the literal provision itself, it will amount to almost 2 pages. So how to make it shorter, right? So you have to write a general thing, right? You comment on administrative power and write generally, right? Citing articles, right? This article do not provide, or you can say that it is more centered towards administration. To the union, the administrative power is centered more towards union. Suppose you have written this, then in bracket write down article, right? So that the checker will understand that okay, this is the article and this is what the assertion that have been made in the answer. This article support that assertion, right? So do not start writing the article line by line there. Okay, so that is the art that you have to develop. Okay, an answer, that is the art that you have to develop, right? So you have to write a lot of information in this particular question. Okay, so try to improve upon that. Okay, so that is very interesting actually. Then critically discuss the financial relationship between state and center and what are the measures that have been suggested to strengthen financial position of the states, right? That is basically one of the commission, right? I think center-state relationship, the Sarkaria Commission, right? They have also recommended some of the measures, right? And you can add from your side for strengthening the financial position of the state. The very one thing that you can do is actually you can say that okay, transfer some of the tax to the state itself, right? So that is the one thing. In fact, GST is a very good thing in that sense. Okay, so those things has to be mentioned here. Okay, so GST, you can say GST Council gives 2/3 voting power to the states, and that is actually quite interesting. Then you will come to the constitutional scheme of the distribution of legislative power weighs heavily in the favor of union parliament, right? So you have to cite different articles, different doctrine, right? And you have to conclude that it is in the favor of the union, okay, not in the favor of a state. Understood, right? What article you can cite? The first article you can cite related to, in the case of conflict, the union will prevail. 2 or more states can request union to make law. Right, so the union have sort of by requesting of a state, the union can expand its legislative power. That doesn't have with the state itself, right? And the one more thing, if the state requests union to make law, right, then that law cannot be changed unless union wants it, right? So once a state choose to forego their power with respect to making a law in a particular list, right, then that power is forgoed itself. Okay, so that is something very interesting in our constitution, right? So you have to cite these examples and then write the answers accordingly. Understood that point? Okay, now today I will ask you to write this question itself. Okay, question number 4, right? So those who have not written it, or I will send the PDF in the Telegram group itself, right? So write question number 4, right? It is one question that basically clubs every concept related to legislature and the executive power distribution. Okay, administrative power distribution. Okay, this is a philosophical question, right? So do not only write the this constitutional articles, apply some method and brain in that. Okay everyone, yes, so that will be all for today. I have explained these 2 topics. Tomorrow I will again explain these 2 topics. Okay, now let me take some questions. Let me check some questions, then I will take questions from you. Okay, yes, so let us start with this guy's question. I don't know whose paper it is because they have not written the name. I have taken 4 papers for today. Discuss the scope of advisory jurisdiction of the Supreme Court. Okay, we have provided the criticism. Okay, so we have talked about the advisory jurisdiction only. Okay, provides for fact or law. Okay, we have taken, we have written about the advisory jurisdiction as given in constitution, then that is okay. Then the value of advisory, not why you are writing, you have to write the criticism part. In such cases, structure, you are writing same argument again, right? Again and again. So that is something very bad. This is a good argument here. You could have given heading criticism number one. The court will appeal, hear appeal after his own advice. Okay, that is the one criticism you can give. Important role in providing the authoritative legal opinion. We have to basically criticize, right? We have to basically criticize. But this is a good argument again, in the favor, not the criticism. And then legislation, okay. Also, same thing you have written in the repetitive argument. Do not repeat the argument, okay? It is very repetitive. See, very poor. Content is poor. Structuring is poor. Okay, so please improve upon them, whoever it is. Now let us come to next question. Discuss briefly. No, that was not the question. At least write the question nicely. Okay, it was the criticism part also. Why to write this? Everyone knows it. Stick to the point, right? Stick to the point. Okay, this is the point, nothing else. Okay. See, you have given one case law in 2002 and then you say later in Ismail Faruqi that happened in 1995. See, the structuring itself is bad. Okay, so please improve upon that. Okay. President. Law of the land. Why to write these facts? कितने बार हुआ, 2 बार हुआ, 10 बार, क्या फर्क पड़ता है उस? Stick to the point, okay? And self-complex issue. See, again, improve upon it. The legal wording is to, things are not. I have told you not to write, more than 5 lines paragraph. You have written almost 10 lines here. Okay, write short paragraph. Please write short paragraph. Opinion. See, again the same thing you have written, what you have written earlier. Very poor content. Okay, improve it. ऐसे कहाँ से 300 नंबर आएगा बेटा? ऐसे लिखोगे तो 300 नंबर नहीं आएगा. समझ में आ रही बात? इम्प्रूव. अब देखिए इसका आंसर देखिए. पहले तो वाइट पेज पे लिखा करो जिसका भी आंसर है ये. आई थिंक गॉड ऑब्वियस. प्लीज राइट, ट्राई टू इम्प्रूव अपॉन इट. ओके, दिस इज द क्वेश्चन. गुड. ओके, इसको ओके. ये तो ऊपर में तो आपने लिखा ही ना, तो इस चीज़ को दोबारा लिखने का क्या मतलब है? अभी तो आप कह रहे हैं लिस्ट 1, कोई मतलब नहीं है. सिंपल रही ना, इसको शॉर्टन करके सिंपल ले सकते हैं. एनी मैटर, दैट्स इट. ठीक ना, वेदर स्टेट और सेंटर, दैट इज ओके. ठीक है, ये सब तो शुरू में आपने लिख दिया है यार. ये सब एक बार लौटा सकते हैं यहाँ पे, कुछ नहीं लिखा है. तो ये तो इंट्रो में आप इसको लिख सकते थे थोड़ा सा. द पर्सन में ऑल्सो सीक एन ओपिनियन. ओके, साइट आर्टिकल्स है ना. आर्टिकल इज नॉट देयर. देयर इज 2 आर्टिकल एक्चुअली. आर्टिकल 131 proviso and there is 143, right? So everyone is mentioned article 143. No one have mentioned 131 proviso. Okay, this is basically 131 proviso. Okay, important matter. Okay, so you have given one of the example of it, right? Okay, where is the criticism now? तो इसमें पैराग्राफ छोड़ दो यार. इसमें ये लिखा है, इसके तुरंत स्टार्ट करो. एक लाइन छोड़ दोगे तो क्या पैसे खराब हो जाएंगे? भाई प्रेजेंटेशन इज वेरी इंपॉर्टेंट राइट. स्ट्रक्चरिंग है, प्रेजेंटेशन भी अच्छी चीज़ है राइट. समझ जो चेक करा उसे समझ में आना चाहिए कहाँ आपने क्या लिखा है. बताइए पैराग्राफ में एक तुम लाइन छोड़ देते क्या चला जाता उससे. ठीक है ना. राइट गुड आंसर्स राइट, जो अपीलेबल हो, देखने में अच्छा लगे. ठीक है गौरव राइट. सो ट्राई टू राइट लाइक दैट. आई थिंक गौरव इज हियर और नॉट, आई डोंट नो. Okay. Right, you've written here criticism or advantage, so you should have given heading here. Again very bad structuring, very very bad structuring. Structuring भी खराब है, presentation भी खराब है. Presentation is also bad. Okay, so please improve upon it. Okay, it is a very bad answer actually. Yes, discuss the scope. Who is he? I don't know. Discuss the scope of advisory jurisdiction of the Supreme Court of India. Oh, okay, the same thing. Good. First particular jurisdiction. Yes, that is a very good intro. Very good intro, right? He or she have cited very nicely, right? Specific. Specifications की जगह और you can use better word, right? Okay. What you have cited 31 as well. Good. Which answer is this? Yes, Mr. Abhishek, it is good. Ambit of evaluation. Yes, very good. Binding value. Yes, you are right. But you know, again, the structuring part has to be there, right? Leave some space, then structure. So you have written this point wise, right? But give heading and subheading. That will make it much better actually. These things, what the advisory jurisdiction, what are the example, you make it shorter, right? Only focus that how it is good, that's it, or bad, whatever your opinion is. You have given too much example. Shorten the examples, right? Let me write the comment. Shorten the examples. Proprietary, hypothetical question. So these are the things that the court have laid down guideline, right? So you can here, give a separate heading. Court have laid down certain restriction and then write it down. Okay. Okay. ठीक है, you have given too much example. That is not required actually. Yes, view enable. How many page you are writing? See, this part is basically half of your answer. You have concentrated in one part itself, right? So when you have a two-part question, give equal focus to both of them. Okay, right? Expand it. Okay, but still relatively it is better, right? I will say it is average. Right, but again, do not write such a long paragraph. No one is going to read, right? Break it, do 4 to 5 lines, then break it. 4 to 5 lines, then break it. So that is very, very important. Okay? Yes. So today I have taken these 4 copies, right? I am trying to give chance to everyone, right? Around 20-30 people sends me copy almost, right? So I am trying to take, each day different people. Okay? Now again, if you have sent the copy, it is not there. You try to compare it with your own copy and, understand by yourself the mistake that you must have committed. Or if it is okay, then that is okay. Understood everyone? Okay, max time before I take around 12, I start taking answers, right? So if you have sent before 12, then that is okay. Yes, it is correct to say, it serves some purpose as well, right? You can be diplomatic about it, good or bad, both cases. Okay everyone? Yes, now I will take answers if you have, questions if you have. Please go ahead. Yes, Mr. Asif Iqbal is asking some. Yes, Mr. Asif, go ahead. First Aswin. Yes, Aswin, go ahead.
Hello, good afternoon, sir.
Good afternoon.
Last year, they had asked a question on PRI. They had asked that revival of Panchayat Raj system in India is an aid to reduce the workload on judiciary.
That was in paper 2, right?
No, sir. In law optional last year, 2019.
There was your question?
Yes, sir.
Yes. In CLD part. Yes. I think.
Yes, sir. So, like, so can you give us some insights as to what has to be written in this?
When I will come to that part, I will give you. Not to worry. If you have this question in these things that I have discussed,
Yes,
we
so
will come.
local bodies, it comes under local bodies.
Acha, in the case of
Yeah.
but that thing I think has to be it has to do with the judiciary as well as this. See, the PRI, it was a philosophical type of question, right? So obviously you have to
Yes,
talk about the all the bottleneck that, right, the judicial challenges that they are facing. Then you can cite the example of the PRI institutions and how, a very interesting fact, in fact, that the PRI, and that is this loan resolution councils that we have at the village level, right? They have in
yes,
fact resolved more loan than the whole, the second and third year tier structure combined. Okay, so that
yes,
is a very beautiful example that you can give. Then you can talk about this lok adalat and the mobile lok adalat, how it makes it easier for everyone. Okay,
yes, sir.
so that sense actually you can cite one by one.
All right, sir. Thank you so much.
Yes, Mr. Asif, go ahead.
Hello, sir.
Yeah.
So I just wanted to know which is better, to write a paragraph or to write in pointers.
See, if you're writing paragraph 4 to 4 lines, and if something has to be told specifically or a lot of information has to be clubbed, then pointer will be okay.
Okay, thank you.
Rashi, I suppose. Yes, I have already given today's question. Here itself is the today's question. This question number 4. Okay, question number 4. Yes, Rashi, go ahead. What question you have?
Sir, can you please tell some pointers as to what we can write in why Article 143 should be abolished?
Okay, I have in the previous class I have told you itself, but still I will repeat it. See, it should be abolished. The court sits in the appeal itself, right? So that makes it redundant actually. It have no legal value whatsoever, right? So it can be always overturned by the court itself, right? Second, it is prone to political use. Like you can say in the case of this this triple talaq case, right? The court actually, the government actually did not pass any law, but they firstly made the previous law unconstitutional by the court, right? They could have simply amended the previous law, but they did not do so. They went to the court, obviously through some other people, not directly, right? That would be not a correct political posturing, right? And then what they did, they come up with a new law with regard to that, right? So that can be done, that advisory opinion can be obtained, and if something has to be done on that advisory opinion, the government can always say to the Supreme Court who is saying this, not me. Okay, so these are the two central arguments that you can give.
Okay, sir. Thank you, sir.
Okay, so I think everyone I have solved everyone's question, right? So today's practice question is this. Try to solve it and submit me, and hopefully tomorrow we will discuss those. Okay, everyone, done? No question at all? Should we wind up now? Yes? 20 marker. All question try to write in 20 marker, because 20 marker can be reduced to simple one. A PDF of answer. Yeah, some of the PDF one answer I will give you. That is a good one. Okay, that I will give you. But rest is not good, so no need to say this. So is this user? Yes, I saw it every day. Yes, user. Go ahead. Last question. Yes.
Hello, sir. Sir, I am asking that can we cite other countries' examples in the advisory jurisdiction?
Yes, you can.
How is-
But if the question talks about, but just as a passing reference, right? Do not spend more than 2 lines on it.
Okay, sir. Thank you, sir.
Yes, today I will take GS paper 2, right? At 9, de facto IS Telegram group, right? If you have filled all the form, then you must have got the email, right? And today at 9 p.m. I will cover that. I will teach it. Okay, Mr. DP Sinha. Yes, go ahead.
Hello, sir.
Hmm.
So my question is that in case I write this in my conclusion that I agree that there are certain shortcomings or there are certain criticisms in on this advisory jurisdiction. However, I still feel that the article should be retained. So is that a correct viewpoint?
Yes, that is correct. See, if you are not being too harsh, if
And
you are
that
simply
can I
giving your
suggest
opinion in a softer format, there is no problem there.
Can I suggest improvements in the lacuna?
Yes, you can, no problem. But the question did not ask, it have asked to make a case for the abolition.
Okay, sir.
Okay.
So we can't write both the sides. In
No,
this.
if they have asked, then. If they have not asked, obviously you should not.
Okay, sir. Thank you.
Thank Okay, are you uploading GS2 lecture? Yes, I will, but not so sure, because this processing and everything I have to first upload on Google Drive, right? And then someone in the back end do the processing, and then it comes to, and then they upload it and do all this stuff, right? So it will take time. It will take time. No, in GS2 no PDF. I am not going to spend. I will simply teach. I will dictate you something. I will write on this itself. So this PDF, if that is generated during the class, that I will send. Then that I can do. That I can. Okay. Yes. So that will be all for today. Thank you very much. Tomorrow 1 p.m. Okay.